I'm Cliff Ribner, and I'm going to talk to you today about how the Supreme Court has been literally gutting major clauses from the Constitution. Instead of interpreting the Constitution, they've been just pretending it says certain things and pretending it doesn't say things that it absolutely says. And how it's been elevating certain professions, particularly the journalism profession and the legal profession, over everyone else. The idea of elevating the legal profession has to do, what they've been doing is, since 1942, they've been interpreting the Interstate Commerce Clause in a manner which permits Congress to pass any law regulating anything it claims involves commerce, if in its discretion it determines that it will help. That's literally what they're doing. That's not what Congress is allowed to do. The Article 1, Section 8 very specifically limits the powers of Congress, and it gives very specific limited powers. And the Interstate Commerce Clause, as James Madison explained in the Federalist 42, it doesn't give Congress any power to impose policing duties on the American citizens or on American businesses. That's the clause they're using. The one clause they're using to turn the entire Constitution on its head. The whole Constitution was dedicated to preserving individual liberty and promoting business. It was recognized that what made us powerful and rich were businesses in America. And they didn't want the government being able to crush business, which is exactly what the Supreme Court has been ruling it can do. It started with a case called Wickard v. Filburn, which affirmed some cases from the 1930s. But in 1942, they determined that it didn't even matter whether it was interstate or not. Anything that they could say involved commerce, anything which had any effect on commerce, Congress was allowed to police in any manner that it wanted. It interpreted that clause that way. And in fact, in the Federalist 42, James Madison, who was the principal author of the Constitution, stated that the purpose of the Interstate Commerce Clause doesn't say anything like that at all. If you actually read the clause, in order to interpret it to permit Congress to regulate businesses simply because they were commerce, under the modern usage of that word, actually at that time the word meant trade. It didn't mean business. But anyway, if you interpret it to permit the federal government to police businesses and anyone involved in commerce, if I talk to you, that's commerce. Any interchange between people is commerce. That's not what the clause means. What James Madison said is the purpose of that clause was that prior to the Constitution, under the Articles of Confederation, states had been bullying out-of-state businesses. And they didn't want that to happen anymore. The most important rights in the Constitution, the only individual liberty preserved in the original Constitution before the Bill of Rights, is freedom of contract. Freedom of contract is what separated free men from serfs. Free men were allowed to engage in contracts and own property. Serfs were not. And under the common law that existed in every state, and still exists, really, it's the law that the states are supposed to use to actually police us. Federal government wasn't supposed to be involved in policing us at all. But under those laws, basically, there's a whole body of law that's the law of contracts. In fact, the Constitution itself is a contract. The whole purpose that the founders had in writing a constitution was to invoke the law of contract, which pre-existed. It was under the common law. They didn't want to abolish the common law. They weren't like the French revolutionaries destroying everything that came before it. They wanted to preserve the common law which existed in every state. They expected every state to continue to police their citizens under the common law, which is the law of free men, which only polices people after the fact. People don't have to go to the government to get permission to do things. That's what differentiates our law, which is the common law, from the laws on continental Europe. Under continental Europe, basically you have to go to the government to ask permission to do anything. That's not the way our laws work. What it is under our laws, in order for that to happen, there has to be a prior restraint. Or in order for you to have to get permission, there has to be some prior restraint, which can only be imposed by a court in a court order after due process. There has to be some reason somebody has to go to court to complain about you saying we need a restraint against this guy, like a restraining order if somebody's harassing somebody else. That's the situation where a prior restraint is permitted. Under our common law, you're allowed to do anything you want in the first instance. It's only if you do something wrong to someone else that they can then sue you after the fact. Or if you commit a crime, the government can bring charges against you after the fact. They don't try to prevent you from, under the common law itself, from committing the crime. Now, we have policemen on the street who are there enforcing the common law, basically, or the criminal law, really, is what the policemen do. And their presence is what's supposed to scare you into not committing a crime. But the law itself doesn't require you to ask permission to do something in advance. You get punished or rewarded after the fact under common law. And the common law was created by courts over centuries, turning into legal fact what exists in the Ten Commandments, enforcing the Ten Commandments. And that's what they do. That's what things like thou shalt not thou shalt not bear false witness, the laws of fraud. We have laws against fraud, both civil and criminal. That's the only way businesses are supposed to be policed. By permitting the government to have all this power, what the federal government's been doing is, what the Supreme Court has been doing is rubber stamping the legality of all of those federal agencies. That's what those federal agencies do. Each of them adds policing power to the federal government against us. They police us. Each time one of them is created, it's based on the claim that some businesses are just crooks, and they have to have the federal government involved to supervise them. That's what, and they call it regulating. What it is, those agencies take away a major attribute of ownership, which is the ability to run your business the way you want to run it. What those agencies do is they impose all sorts of rules. They're not allowed to do that. Under the Constitution, Congress is the only one that's allowed to create laws. They write laws. They don't call them laws because they can't. They call them regulations because in order for a law to be a law, it has to comply with the procedures of Article 1, Section 7 of the Constitution, and none of those things do. These are regulations written by unelected bureaucrats in the dead of night, and they're totally unconstitutional, every one of them. But what they do is they criminalize ordinary behavior by citizens. That's what they do. And it's been interpreted that every time you violate one of those things, it's a crime. So they're adding to the criminal prosecution that the Justice Department can impose on citizens. They're adding to the ability of the federal government to police the citizens. So the agency gets created, and then it writes its own laws on top of that. Totally unconstitutional. But what this does is it empowers the legal profession, because no business can function without having teams of lawyers interposing themselves between those agencies and the business. That's why the legal profession has gotten so powerful. The bigger the government gets, the bigger the law firms get. When I was in law school, the biggest law firm in the country had 200 lawyers. That's not even a middle-sized law firm now. There are law firms now with thousands of lawyers because they have to have people that are expert in each area of those quote-unquote regulations that are created. Anyway, it's empowered the legal profession. What's also happened, the Supreme Court has differentiated between different types of speech. Now, it's not just doing this by itself. What it's doing, it's rubber stamping what Congress and presidents have done in legislation. For example, all of those federal agencies, like the SEC, dictates what every public company can say. Every time its stock goes up, or every time its stock goes up for sale, the whole process, they literally dictate every detail over what that business could say to the public. And after that, they dictate everything that company can say whenever it communicates with its shareholders, with anybody. They have all sorts of rules about all sorts of things. They've invented their own concept of fraud. They've added causes of action against companies. 10b5. Anyway, that's what the SEC does. But there are other agencies that also regulate speech. I mean, the First Amendment is very clear. Congress shall make no law impairing freedom of speech. That's one of the freedoms in there. And every one of those agencies do that. They dictate what all sorts of companies and people are allowed to say. In fact, the Supreme Court has come up with this crazy idea that there's a difference between commercial speech and other speech. And that there's nothing in the Constitution saying that Congress shall make no laws about all speech except commercial speech. That's not what it says. It says speech, freedom of speech. It's very clear. But the Supreme Court has come up with this differentiation. And what's happened is the whole legal profession loves this stuff. In fact, law schools, basically, when you go to law school, you're taught to worship the Supreme Court and how brilliant they are, that they've come up with all these ideas, like differentiating between commercial speech and real speech that Congress can't make any laws about. The FDA dictates what any drug company or any food company can say about its products. And they say this as it's a prior restraint. It's one thing if these companies are making fraudulent claims so that they get sued by people after the fact. This is different. This is imposing a European type of law on us. And it's not permitted under the Constitution. And what they've done is they've also differentiated between the press and everyone else. For example, in the McCain-Feingold law, which George Bush signed, he signed it even though he said it was unconstitutional. But he went ahead and signed it anyway. And he was right, it is unconstitutional. But the Supreme Court won't say that, or at least it hasn't said it yet. All of those laws involving regulation of speech involved with campaign finances or with political speech. It's the most protected kind of speech there is. It's the most regulated. So you can't run for office without having an army of lawyers there to tell you what you can say and when you can say it and who you're allowed to get money from. And there's all these rules. They've made a distinction between the money involved in candidates projecting their speech and the speech itself. It's nonsense. It's total nonsense. You can't run for office unless you're just running for president of your block without having some way to amplify your speech. And that's what money does. And for example, at my law school, they have the Brennan Center. Brennan Center is there to come up with ways of breaking down each right into different little chunks so that the right can be diminished. It's all funded by George Soros and lots of other rich people. It's disgusting. They have people like the weathermen there as speakers. I'm not kidding. Anyway, Bernadette Dorn was one of their speakers. And they have people like that all the time. Left-wing judges. They parade them. But what they do is they come up with ways of limiting the speech of actual candidates and actual citizens, limiting the ability to raise money to generate the speech. And what they've done also is they've given the press special privileges, and there's two different types. One of them is in a case called New York Times v. Sullivan. They gave the press the right to slander anybody, as long as the person who they slander can't prove that it was malicious, that the press really knew 100% that it was a lie. That's basically the test. So as a practical matter, public figures have to sit there and be lied about constantly. But when you have a situation where 99% of the press is in the tank for the Democrat Party, it basically becomes an unlimited political contribution to the Democrat Party. They look at all the things they said about Donald Trump. They call him a Nazi. They call him a fascist. They do this routinely. Nothing happens to them. He's trying to sue them now, but it's very difficult. Fortunately, he's very rich independently, but that has nothing to do with anything the government has done for him. He made all that money himself. But normally, he wouldn't be able to sue them at all as a public figure. They came up with this idea in New York Times that anyone who qualifies as a public figure, whether they became that voluntarily or not, has to prove special extra malice in order to maintain a lawsuit for defamation against anyone in the press. So the press gets to say anything they want about anyone at any time, just because they're the press. And that's what but they don't let anybody else do that. So they have special rights in the context of both politics. They're allowed to spend as much money they want amplifying their megaphone, even if it's all for one side, as it has been for decades, as any sentient person knows from watching TV. All the networks, most of the newspapers in the country. They're allowed to say anything about anybody running for office. All these public figures, and they can lie. They can accuse President Trump of being a Nazi and a fascist. And only recently has there been any attempt to even deal with that. Anyway, they have that right. And they also have the privilege of saying anything they want anytime that nobody else has. They have a special right both in the political sphere and when it comes to slandering individuals who are public figures. But you have to remember, when the nation was founded, there were no such things as organized professions. Yes, the Constitution says there shall be freedom of the press. What they meant is that anybody engaged in printing stuff should have absolute freedom. It's part of freedom of speech that everybody has. There weren't any things like professional licenses. You didn't have to be licensed. There wasn't some accreditation thing for the press. There still actually isn't. Anybody can say they're in the press now. And it's interesting to watch the mainstream media very angry about the fact that bloggers can claim that they're in the press, so they can say anything they want. So that cuts both ways. Anyway, there was no licensing for lawyers, even though most of the people who participated in the creation of the Declaration of Independence and the Constitution were lawyers at the time. They weren't licensed. Now, courts could admit people and let people be lawyers in front of them, but there wasn't some licensing by the states. There wasn't what it is in the Middle Ages. Various trades made themselves more important than everybody else and kept everybody out who didn't comply with their rules. They called themselves guilds. And the idea of elevating the various professions into more above other people, that's what happened. That was a 19th century idea. Like law schools were formed for the first time. Columbia was one of the first law schools. And lawyers began going to law school. And then eventually they were getting licensed by states. All of that is totally unconstitutional. There's nothing in the Constitution that permits states to license professionals. And in fact, in the Declaration of Independence, when the founders said they were fighting the revolution for life, liberty, and pursuit of happiness, what they meant by that was engaging in whatever trade or business you want to engage in. If people don't want to buy your services, too bad for you. They don't guarantee you'll have customers. But that was part of what they were fighting the revolution for. The idea of giving states some licensing control over that, where they could pull the license and prevent you from engaging in your trade or business, is totally antithetical to the Constitution. And by the way, that interpretation of that term was recognized by the Supreme Court in the late 19th century in a case called Allgaier v. State of Louisiana. It recognized that the Declaration of Independence, talking about life, liberty, and the pursuit of happiness, those are part of the rights that are preserved in the Constitution, in the 14th Amendment. And by the way, all of our rights come not from the founders, not from the state, but from God. That's the nature of our country. It says it right in the Declaration of Independence. So that it's basically describing rights. It's enumerating the rights which God gave us. And we have more rights than that. In the 9th and 10th Amendment, it says any power not given to the federal government in the Constitution is retained by the people or the states. So this people and the states are supposed to have all the power in our republic. What's happened is the federal government has stolen power for itself, and it's given special rights to lawyers and to the press. And none of that is permitted under the Constitution. And part of the way they've been doing that is by restricting freedom of contract and by enhancing the power of the federal government by claiming that the Interstate Commerce Clause gives the federal government the power to police any aspect of life, which thereby empowers the legal profession. So this makes the legal profession very arrogant because it becomes a necessity. And there's a specific thing in the Constitution. There should be no titles of nobility here. Basically, they're trying to create titles of nobility, that's the nature of the press and lawyers, and all these titles that all these bureaucrats have. These bureaucrats who get to police us in all sorts of ways. And most people don't see it. The only bureaucracy they come in contact with for the most part is the IRS. But there's hundreds of them. And if you're in a business that's regulated by them, and they all are, if you own a business, you know all about this. There's lots of these agencies that are right there, right at your throat. And they have the power to destroy your business and everyone who works for it if they want to, so that you have to do whatever they say. You are completely under their thumb. And that's not the way this country is supposed to be. This is supposed to be a country that fosters businesses, that permits the states to police the citizens. And by the way, there's only 2 crimes that the federal government is actually allowed to enforce against the citizens. It's right in Article 1, Section 8. Piracy, but only on the high seas, and counterfeiting. And the Fed, which is one of these agencies they created in 1913, which monopolized the currency, it violates the crime of counterfeiting every single day. Every time it prints that money that isn't backed by anything. And the reality is, under the Constitution, the federal government's not allowed to print any money at all. That's something it just stole from us. And every time the federal government takes power from us, it's a one-for-one thing. It takes power for us, it gives it to itself in an equal quantity. And this country was supposed to be, and was, founded on the basis of promoting individual liberty. And the government's been stripping us of that ever since it started in with this nonsense. I'm Cliff Ribner, and if you like what I have to say, please like this video. Please go to my website, cliffordribner.com, and read my book, Freedom's Last Stand. Thank you.